Erwin Chemerinsky, returning to us for his 9th year. As you know, he is a Harvard Law School graduate. He's taught at USC and Duke University Law School. In 2008, he founded UCI's prestigious law school. Professor Chemerinsky is a leading constitutional law scholar, a renowned Supreme Court expert, a teacher of judges and justice. He's written countless articles and writes a weekly column for the OC Register. His books include The Case Against the Supreme Court. Please give a very big welcome to Dean Chemerinsky.
Thank you so much for the incredibly kind introduction and the very warm welcome. It's truly my honor and great pleasure to be with you. Everything changed in the United States Supreme Court on Saturday, February 13th, when Justice Antonin Scalia died. From 1971, when Richard Nixon's third and fourth justices were confirmed for the Supreme Court, until February 13th, there were always at least 5 and sometimes as many as 8 justices appointed by Republican presidents. But now there are 4 justices who are appointed by Republican presidents, Chief Justice Roberts and Justice Kennedy, Thomas Alito, and 4 justices who are appointed by Democratic presidents, Justices Ginsburg, Breyer, Sotomayor, and Kagan. Who replaces Justice Scalia is truly crucial to the balance with regard to politics and ideology on the Supreme Court. Once Justice Scalia passed away, it was obvious there were going to be a significant number of cases where the court was going to be deadlocked 4-4. If you look at the prior decade, on average, there have been 10 cases a year that were 5-4 with Justice Scalia in the majority. When the justices are deadlocked, they have 3 choices. One is they can affirm the lower court decision without an opinion by an evenly divided court. Whatever the lower court decided is the result in that case. There's no Supreme Court precedent. The justices are free to take up the issue again in the future. That happened 5 times in the term that concluded on Monday, June 27th. A couple were very high-profile cases. One was Friedrichs versus California Teachers Association. In 1977, in Abood versus Detroit Board of Education, the Supreme Court reaffirmed that no one can be forced to join a public employees union. But the court said that non-union members can be required to pay the share of the dues that go to support the collective bargaining activities of the union. The Supreme Court said non-union members benefit from collective bargaining. They benefit in terms of their wages, their hours, their working conditions. The court said they shouldn't be able to be free riders benefiting without paying. But the court said that non-union members cannot be required to pay the share of union dues that go to support the political activities of the union. The court said that would be impermissible compelled speech. In a couple of recent cases, decisions I've talked with you about in past years, the 5 conservative justices sharply criticized Abood and indicated willingness to overrule it. Rebecca Friedrichs is a middle school teacher at a public school here in Orange County. She filed a lawsuit in federal court in Santa Ana. Her lawyers went before the federal district court judge, Josephine Staten, and asked the judge to overrule the Supreme Court's decision in Abood. Judge Staten, of course, said, I am a federal trial court judge. I can't overrule the United States Supreme Court. And the lawyers for Friedrich says, that's right, you can't. Just rule against this so we can get to the higher court. It then went to the Federal Court of Appeals. The lawyers for Rebecca Friedrichs asked the Federal Court of Appeals to overrule the Supreme Court decision of Abood. The Federal Court of Appeals said, not even we. The United States Court of Appeals for the Ninth Circuit can overrule the Supreme Court. And lawyers for Friedrich said, that's right, just enter judgment against us. The Supreme Court granted review. The case is unusual, if not unique, and that it came to the Supreme Court with absolutely no record. It was just a vehicle for the Supreme Court to overrule Abood. Case was argued in the Supreme Court on Monday, January 11th. I've never read a transcript of an oral argument that was clearer as to what the result was going to be. Not one of the 5 conservative justices asked a single question, made a single comment, left doubt as to how he was going to vote. I can only imagine how the lawyers on both sides felt on Saturday, February 13th, when they heard of Justice Scalia's death. For lawyers for Rebecca Friedrichs and the National Right to Work movement, this was certain victory that they labored for years being snatched away. For lawyers for the unions, it was an enormous sigh of relief. If the Supreme Court overruled Abood, it would mean in California and 21 other states a dramatic decrease in revenue for unions, a decrease in membership for unions. Nationally, it would tremendously diminish the political influence of unions. Quite predictably, the Supreme Court announced it was split 4-4. The lower court decision stands. Abood remains the law, at least for now. In the longer term, the outcome is going to depend on who replaces Justice Scalia. If, for example, it's Merrick Garland or a Democratic appointee who replaces Justice Scalia, I think Abood is secure. If, though, it's a Republican nominee who replaces Justice Scalia, then the overruling of Abood is just delayed. The other example that I give you of a 4-4 split involves another of the high-profile cases of the term. It's called United States versus Texas. I confess I like the name of that case. In November 2014, President Obama announced his immigration action called Deferred Action for Parents of Americans. It applies to non-citizens who are not lawfully in the United States if they've been here since at least 2010, if they don't have a criminal conviction, and if they have a child who's an American citizen or a lawful resident alien. It's estimated that there may be as many as 5 million people who meet these criteria. President Obama said, we don't want to break up families. We're going to give these individuals deferred deportation status for at least 3 years. Texas and 25 other states brought a lawsuit arguing that this was illegal and unconstitutional. A federal district court judge in Texas ruled against the Obama administration. He gave a nationwide preliminary injunction preventing DAPA from going into effect anywhere in the country. The Federal Court of Appeals, the United States Court of Appeals for the Fifth Circuit, affirmed in November 2015. And on Thursday, June 23rd, the Supreme Court announced that it was split 4-4. That means the lower court decision stands. DAPA doesn't go into effect. Again, what's going to happen is going to depend on the next president. If Hillary Clinton is elected, I think she's going to continue DAPA. If Merrick Garland or a Democratic nominee is confirmed for the court, they're going to uphold DAPA. Certainly, if Donald Trump is elected president, he's going to rescind DAPA. So that's one thing that can happen when the justices are deadlocked. They split 4-4. Whatever the lower court decided stands. A second possibility that's available to the justices is to look for a narrow ground to decide a case. Not resolve the big issue, but find some limited way that a majority can agree upon to decide the case. That happened many times this term. The most famous of these was a case called Zubik versus Burwell that involved the contraceptive mandate under the Affordable Care Act. The Patient Protection Affordable Care Act, commonly referred to as Obamacare, required that the Department of Health and Human Services promulgate rules to require that employer-provided insurance also provided for preventative health care coverage for women. We all know that traditionally, insurance would provide benefits only if someone was ill. Congress wanted to make sure that employer-provided insurance included well care coverage for women. Health and Human Services adopted regulations. One part of them involves contraceptive coverage. For example, it says that religious institutions that oppose contraception, like the Catholic Church, don't have to provide contraceptive coverage for women employees. For not-for-profit institutions that are affiliated with religions that oppose contraception, it has a different provision. Think here of a Catholic university. What was much discussed at the oral argument, think of the Little Sisters of the Poor, an order of nuns that brought a challenge to this. The regulation here said that all the not-for-profit would need to do is file a statement with the insurance provider of the federal government that it opposes contraception on religious grounds. Then, at no cost to that institution, the insurance provider of the federal government would provide contraceptive coverage for women employees. All over the country, not-for-profits brought challenges against this. They said if they file that statement with the insurance provider of the federal government, it will trigger the insurance provider of the federal government providing contraceptive coverage. They said that would make them complicit. They said that's a substantial burdening of their religion. 5 federal court of appeals, including the one here on the West Coast, rejected that argument. They said, that's not enough to be a substantial burden of religion. It's not costing you anything. 1 federal court of appeals accepted the argument. The Supreme Court granted review. Then, after oral argument, when it looked like the justices were split 4-4, they did something that I've never seen before. It may be unprecedented. The justices proposed their own compromise and asked the parties to brief it. The justices said, what if the employer just tells the insurance provider that it doesn't want to be involved with contraceptive coverage at all, and women employees filed their claims right with the insurance provider? The religious institutions filed a brief in the Supreme Court saying, that looks great to us. The Obama administration filed a brief in the Supreme Court saying, this won't work. For example, what if the not-for-profit institution is self-insuring? Who then would women employees file their claims with? The Supreme Court then, in a short opinion of the court, said, since both sides see a viable compromise here, we're going to send the case back to the lower courts. No one has any idea what happens now. Now, in theory, the Obama administration could rewrite the rule in the way the Supreme Court suggested, but why would it do that? It won in 5 out of 6 Court of Appeals. Besides, especially if Justice Scalia is replaced by Merrick Garland or a Democratic appointee, it's quite likely that there'll be a court to uphold the regulation. So this, too, depends on who wins the presidential election. If Hillary Clinton wins, if Merrick Garland or a Democratic nominee is confirmed, I think what will happen is the Obama administration regulation will go in effect. If Donald Trump wins, then I think it's very likely that these regulations, most of those to enforce the Affordable Care Act, will be rescinded. So the justices had a third choice if they were deadlocked 4-4. They could affirm the lower court, they could look for a narrow ground to decide, or third, they could put the case over for re-argument next year. Tradition is that a case is decided in the term in which it's argued. But there are many high-profile cases in which a case was argued one year, not decided that year, put over for re-argument and decision the next. Brown versus Board of Education was originally argued in the Supreme Court in October term 1952. The justices couldn't come to a decision, so they put it over for re-argument the next year. It was decided in October term 1953. Actually came down on May 17, 1954. Roe versus Wade. It was originally argued in October term 1971. There were only 7 justices on the bench that term because Justices Black and Harlan had resigned and not yet been replaced by Justices Powell and Rehnquist. So the justices decided to put the case over to the next year, October term 1972, decided in January 1973. Citizens United versus Federal Election Commission. Originally argued in October term 2008 on a very narrow statutory ground. The justices on their own raised a constitutional issue. It was re-argued the next year, decided in January 2010. But what's interesting is not once this past term did the Supreme Court put a case over for re-argument for next term. I think there's a practical explanation. The justices know that it's no more likely next year that there'll be 9 justices than we had this past year. Senate Republicans have made clear there's going to be no hearings on, no vote on Merrick Garland, at least until the November election. Now, I should pause here for a moment of disclosure. I've known Merrick Garland since the late 1960s when we were competitor high school debaters in the Chicago area. We also went to law school together. He was a year ahead of me in law school. In fact, the morning that President Obama nominated Merrick Garland for the Supreme Court, my oldest son called me and said, "You've known him a long time. What do you think of him?" And I said that I think that Merrick is a brilliant man, truly a decent person. And I said to my son, look at it this way. Merrick Garland is a Jewish man in his early 60s who had Eastern European grandparents. He grew up in the Chicago area. He was a high school debater and went to Harvard Law School. I could also say he's relatively short, has gray hair, and wears glasses. What's not to like about that? I think if Hillary Clinton is elected president, there's a real chance that the Republican Senate could confirm Merrick Garland in December. Merrick will be 64 years old then. By all accounts, he's moderate. I could imagine that Senate Republicans would rather have a 64-year-old moderate than take their chances on a much younger liberal. But even then, he'll miss the oral arguments in October, November, and December. If it's the next president who appoints Justice Scalia's replacement, then I don't think there'll be hearings until late next spring, and the court will go all of next term with just 8 justices. There's no doubt that at this moment in time, we're living under the Anthony Kennedy court. Last year, the Supreme Court decided 63 cases after briefing and oral argument. It's the fewest number since at least 1932, which is as far back as I can find statistics. And Anthony Kennedy was the majority in 98% of all of the decisions. I can identify no year in recent memory when just in the majority nearly so often. But Justice Kennedy's pivotal role will change as Justice Scalia's replacement is appointed. Also, as you look at the longer term about the Supreme Court, which I really want to focus on here this afternoon, since 1960, 78 years old is the average age at which a Supreme Court justice has left the bench. On January 20th, 2017, the day the next president is inaugurated, there will be 3 justices on the court, 78 or older. Ruth Bader Ginsburg turned 83 on March 16th of this year. Anthony Kennedy turned 80 on July 23rd. Stephen Breyer turned 78 on August 15th. Especially if the next president serves 2 terms, he or she is likely to have 3, depending on what happens to Justice Scalia's seat, 4 vacancies to fill. That will literally affect every area of constitutional law. Let me pick 6 areas to talk about to show you how important this election is for the composition of the Supreme Court and for all of our rights. I'll list them for you alphabetically. The first is abortion rights. In 1973, in Roe v. Wade, the Supreme Court held that women have a fundamental right to choose whether to terminate their pregnancies before viability. By the 1990s, there was a good deal of uncertainty whether because of changes in the composition of the Supreme Court, Roe v. Wade would be overruled. We now know, thanks to Justice Blackmun's papers being made public, that when the justices first voted in conference in Planned Parenthood versus Casey in the spring of 1992, it was going to be a 5-4 decision to overrule Roe v. Wade. We came that close to Roe being overruled. But between the time the justices voted in their private conference and when the case was announced, Justice Kennedy changed his mind. He joined with an opinion of Justice O'Connor and Souter, and Justice Blackmun and Stevens went along to reaffirm Roe v. Wade. But between June of 1992 and June 27th of this year, Anthony Kennedy never again voted to strike down an abortion regulation. In every case from 1992 to June 27th, 2016, Justice Kennedy always voted to uphold the restrictions on abortion. The case decided on June 27th was Whole Women's Health Center versus Hellerstedt. Did you know that since 2010, state legislatures across the country have adopted 290 new different statutes to impose restrictions on abortion? These laws are often called targeted restriction of abortion providers. The first of these cases to come to the Supreme Court is from Texas. In Texas, it was called HB2. You might remember Wendy Davis leading an unsuccessful filibuster against it. Two key provisions were for the Supreme Court. One said that in order for a doctor to perform an abortion, he or she had an admitting privilege at a hospital within 30 miles. Generally, these hospitals will not give the doctors admitting privileges. Sometimes that's because the hospital is religiously affiliated. Often it's because the hospital has a requirement that the doctor admit a minimum number of patients. Abortion is such a safe procedure, rarely will the doctors admit patients and meet the minimum requirement. The other provision says, in order for abortion to be performed in a facility, the facility has to have surgical quality facilities. It has to have hallways big enough for 2 gurneys, HVAC facilities used in operating rooms. Before Texas adopted the law, there were 40 facilities in the state where abortion provided. When it briefly went into effect, it went down to only 20 facilities in the state where abortions are provided. If the Texas law is upheld, that would have left only 7 or 8 facilities in the whole state of Texas where abortions are performed. A federal trial court in Texas issued a preliminary injunction. He said there's no evidence that this law will do anything to protect women's health. He says there's no need for doctors to have admitting privilege at a local hospital. If a woman was having complications, whereas they are, she'd be taken to the emergency room and the doctor there would provide treatment. No need for surgical quality facilities because there's no surgical procedures being performed. No need for hallways big enough for 2 gurneys because gurneys aren't used. The federal district court found that the entire purpose of the law was to impede women's access to abortion. The United States Court of Appeals for the Fifth Circuit reversed. The Fifth Circuit said it should be for the Texas legislature, not for the court to decide if the law protects women's health. On Monday, June 27th, the Supreme Court, in a 5-3 decision, reversed the Court of Appeals and declared the Texas law unconstitutional. Justice Breyer wrote the opinion for the court, joined by Justices Kennedy, Ginsburg, Sotomayor, and Kagan. Justice Alito wrote a dissent, joined by Chief Justice Roberts. Justice Thomas wrote a dissent, urging the immediate overruling of Roe v. Wade. Justice Breyer recited what the trial court found, that this law would create a substantial obstacle for women having access to abortion, and it would do nothing to protect women's health. It's so crucial that Justice Kennedy was part of the majority there. Had he joined with Chief Justice Roberts and Justice Thomas and Alito, it would have been 4-4. The lower court decision stood. The Texas law would have gone into effect. Justice Ginsburg wrote a short concurring opinion. She said, be clear. This means that all of these recently adopted targeted restriction of abortion provider laws are unconstitutional. And in the couple of months since, federal trial courts in a number of states, most recently Indiana and Wisconsin, have declared unconstitutional their so-called trap laws. If Hillary Clinton wins and replaces Justice Scalia, as well as in the longer term from among them, Justice Kennedy, Ginsburg, and Breyer, abortion rights are secure for decades to come. But if Donald Trump wins, and he gets replaced Justice Scalia, and from among them Justices Kennedy, Ginsburg, Breyer, then Roe v. Wade will be overruled. Chief Justice Roberts and Justice Alito and Thomas will vote to overrule Roe v. Wade now. If Trump gets 2 picks for the court, and it seems almost certain he will, Justice Scalia's and at least one other, then there will be a majority to overrule Roe v. Wade. Second example, affirmative action. In 2003, in a case called Grutter v. Bollinger, the Supreme Court held that colleges and universities have a compelling interest in having a diverse student body. The court said colleges and universities may use race as one factor among many in their admissions decisions to benefit minorities and enhance diversity. The regents of the University of Texas in 2004 looked at their undergraduate population. They saw that it was less racially diverse than it had been even just 8 years earlier. There were fewer African American students at the University of Texas in 2004 than had been in 1996. So they adopted a new admissions plan. They said, pursuant to state law, they would take about 75% of each freshman class by accepting the top 10% from every high school in the state. Texas is sufficiently racially segregated that would produce some degree of diversity. But it still wouldn't get Texas back to even the 1996 levels of diversity. So they said for the other 25% of the entering class, they would do an individualized review of every application. For each applicant, an admission score was calculated. It was the sum of two numbers. One was called the Academic Achievement Index. That's the student's grades and test scores. The other is called the Personal Achievement Index. This was arrived at by grading 2 essays required in the application for admission and looking at 7 factors. One of the 7 factors is what the student would contribute to diversity at the University of Texas. Texas thought it was doing just what the Supreme Court prescribed, using race as one factor among many in admissions decisions. Abigail Fisher, a white woman, applied for the University of Texas in 2008. She wasn't in the top 10% of her class, so she didn't get in that way. And individualized review led to her being rejected. She enrolled in Louisiana State University, from which she graduated in May 2012. And I can only imagine how her alma mater, Louisiana State University, feels about hearing her say in court she was terribly, horribly injured by having to go to Louisiana State University rather than her preferred school, the University of Texas. But when she was denied admission to the University of Texas, she brought a lawsuit saying its consideration of race violated the Constitution. On Thursday, June 23rd, the Supreme Court, in a 4-3 decision, upheld the University of Texas program. Justice Elena Kagan is disqualified from being involved in this case because she'd been Solicitor General of the United States when this case was being handled in that office. Justice Scalia, of course, passed away before the case came down. Justice Anthony Kennedy wrote for the court, joined by Justice Ginsburg, Breyer, and Sotomayor. Justice Alito wrote an angry 52-page dissent, joined by Chief Justice Roberts. Justice Thomas wrote a separate dissent. From the time Anthony Kennedy came on the Supreme Court in February 1988 until Thursday, June 23rd, he never once voted to uphold an affirmative action program. Not in education, not in contracting, not in employment. But he wrote the opinion in Fisher upholding the Texas affirmative action program. He said that Texas had proven the compelling need for diversity. It had shown no other way to achieve it. He concluded his opinion by talking about the need to defer to academic institutions and their judgments about the importance of diversity and how to achieve it. It is a stunning victory for affirmative action in higher education. What this will mean in the longer term is going to depend on who replaces Justice Scalia and the other justices. If Hillary Clinton replaces Justice Scalia, or it's Merrick Garland, another Democratic nominee, then I think colleges and universities that want to engage in such race-conscious admissions decisions will be allowed to do so, and for decades to come. But if it's Donald Trump who replaces Justice Scalia, and some from among Justices Kennedy, Ginsburg, Breyer, then there's no doubt that these cases will be overruled, affirmative action will be eliminated, and it will then mean at public and private universities across the country very little in terms of race diversity. Third example, campaign finance. As everyone here knows, as I've talked with you so often before, in 2010, in Citizens United versus Federal Election Commission, the Supreme Court held that corporations can spend unlimited amounts of money out of their corporate treasuries to get candidates elected or candidates defeated. Citizens United versus Federal Election Commission was a 5-4 decision. The 5 in the majority were Kennedy, Roberts, Scalia, Thomas, and Alito. Without Justice Scalia, the current court is split 4-4. And it's not just about Citizens United. A couple years after that, the Supreme Court decided a case called Arizona Free Enterprise Club versus Bennett. There was a major scandal involving corruption of the Arizona state legislature. Arizona voters passed an initiative that creates a system of public funding for elections for state offices. No candidate is required to take public funding, but candidates could opt to do so. If a candidate decided to take public finance, there'd be requirements. The candidate would have to participate in debates. Now, the concern was, what if one candidate takes public money, the other doesn't? What if the other spends so much more so that the candidate who took public money is at a disadvantage? The Arizona law addresses that and says, if the other candidate doesn't take public money and spends more than the amount of public money, the public money will be increased up to a capped amount. The Supreme Court, 5-4, declared that unconstitutional. The majority was Roberts, Scalia, Kennedy, Thomas, Alito. I've never understood why this in any way infringes freedom of speech. It doesn't restrict anyone's speech, doesn't force anyone to take public money, doesn't, even if those who take public money, limit what they can do. It just says the government will increase the amount of public dollars. But that was unconstitutional. Here, too, without Justice Scalia, the court is split 4-4. So if Hillary Clinton gets to replace Justice Scalia, as well as justices among them Kennedy, Ginsburg, Breyer, I think Citizens United will be overruled. Indeed, Hillary Clinton said in her acceptance speech at the Democratic Convention, she wants justices who will do that. I think, though, if Donald Trump gets to replace Justice Scalia, there'll then be 5 votes to continue Citizens United. And if he gets to replace from among them just Kennedy, Ginsburg, Breyer, I think there'll be an even more secure majority to strike down campaign finance laws, federal, state, and local. A couple of years ago, Ruth Bader Ginsburg gave a speech in San Diego in which she said that history will regard Citizens United as one of the worst Supreme Court cases ever. I think she's right. I think it gives to corporations the ability to literally decide the outcome of elections, even cause people to choose not to run. And so the future of campaign finance, the future of Citizens United, is going to depend on who wins this election. Fourth example, the death penalty. I believe there are 4 votes on the current court to declare the death penalty inherently unconstitutional as cruel and unusual punishment. In June of 2015, in a case called Glossop versus Gross, the Supreme Court upheld the drug protocol used for lethal injections. It was a 5-4 decision. Justice Breyer wrote a dissent, joined by Justice Ginsburg. Justice Breyer urged the other justices to ask for briefing and argument as to whether the death penalty is inherently unconstitutional, is cruel and unusual punishment. At some length, Justice Breyer made the arguments as to why he believes the death penalty is unconstitutional. He said there's too great a risk of executing innocent individuals because of wrongful convictions. He said that the death penalty is carried out in the United States is so arbitrary as to be cruel and unusual punishment. So there's no evidence that the death penalty deters crime or other benefits. Justices Sotomayor and Kagan wrote their own separate dissent that didn't focus on this. But knowing their views on other issues, I think if there were ever a 5th vote, there would then be 4 votes on the current court to declare the death penalty unconstitutional. I think this, too, is going to depend on the outcome of the next election. Now, if Merrick Garland is confirmed, I do not think he will be the 5th vote to declare the death penalty unconstitutional. Merrick Garland tends to be quite conservative on criminal justice issues, I think even more conservative than Justice Scalia was on criminal law questions. But if another Democratic nominee replaces Justice Scalia, if Justice Kennedy, for example, is replaced by Hillary Clinton, then I think there'll be 5 votes to end the death penalty, holding to be cruel and unusual punishment. But if Donald Trump replaces Justice Scalia, if Donald Trump replaces from among them Justice Kennedy, Ginsburg, Breyer, then it seems sure thing that the death penalty will continue to be regarded as constitutional for years, if not decades, to come. 5th example, guns. The language of the Second Amendment is an enigma. It says, and I quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." From 1791, when this provision was adopted, until June of 2008, the Supreme Court always held that the Second Amendment is just a right to have guns for militia service. This is what it says. From 1791 to June of 2008, not once did the Supreme Court declare unconstitutional any federal, state, or local gun control law. But then in June 2008, the court decided a case called District of Columbia versus Heller. It involved a 32-year-old District of Columbia ordinance that prohibited private ownership and possession of handguns. The Supreme Court, 5-4, declared the law unconstitutional. Justice Scalia wrote, joined by Chief Justice Roberts and Justice Kennedy, Thomas, and Alito. Justice Scalia said, "The Second Amendment protects the right of people to have guns, at least in their homes, for the sake of security." 2 years later, in 2010, in McDonald versus City of Chicago, the court struck down a Chicago ordinance regulating guns. Same 5-4 margin, same split among the justices. The current court, without Justice Scalia, is split 4-4 between 2 very different views of the Second Amendment. The conservatives believe that the Second Amendment is a right of individuals to have guns, the gun rights position. But there's 4 liberal justices who think the Second Amendment is just about a right to have guns for militia service. It has no right other than that. It doesn't eliminate any other gun control laws. Well, who replaces Justice Scalia is crucial. Who replaces Justice Kennedy, Ginsburg, Breyer? Equally crucial. If Hillary Clinton gets to replace some or all of these justices, I think the Supreme Court will not provide additional protection of gun rights. I think they may very well overrule District of Columbia versus Heller. But if Donald Trump appoints the replacements for Justice Scalia, and among them Justice Kennedy, Ginsburg, Breyer, then I think the Supreme Court will expand the gun rights position. Many other laws regulating guns will be declared unconstitutional. 6th and final example, separation of church and state. In 1947, in Everson versus Board of Education, all 9 justices agreed that the provision of the Constitution that there should be no law respecting the establishment of religion was best explained by words from Thomas Jefferson. Thomas Jefferson is the one who said there should be a wall that separates church and state, a wall that's high and impregnable. It wasn't liberals on the current court. It wasn't progressive law professors who came up with the metaphor of a wall separating church and state. It was Thomas Jefferson long ago. But in recent years, the conservative justices on the court have taken a very different view. They have repeatedly said that the government violates the Establishment Clause of the First Amendment only if the government literally establishes a church or coerces religious participation. For them, nothing else ever violates the Establishment Clause. In the spring of 2005, I argued a case in the Supreme Court, Van Orden versus Perry, that involves a 6-foot-high, 3-foot-wide Ten Commandments monument that sits right at the corner between the Texas State Capitol and the Texas Supreme Court. I was representing a homeless man, Thomas Van Orden, who filed a lawsuit on his own behalf. At the oral argument in the Supreme Court in March of 2005, Justice Kennedy said to me, with real hostility in his voice, If your client doesn't like the Ten Commandments monument, why doesn't he just look the other way? What I said then and still believe now is we don't excuse a constitutional violation by ignoring it. There'd be no stopping point to that position. A city could put a large cross atop City Hall and say, if you don't like it, look the other way. The importance of this ideological divide with regard to separation of church and state is illustrated by a Supreme Court decision just a couple of years ago. And I've talked about with you in past years, a case called Town of Greece versus Galloway. Town of Greece is outside of Rochester, New York. It's about 100,000 people. For many years, every month, the town board would invite a Christian clergy member to deliver a prayer before the town board meeting. Almost always, these prayers were explicitly Christian in their content. Question is, does that violate the Establishment Clause? The Supreme Court 5-4 held it doesn't violate the Establishment Clause. Justice Kennedy wrote, joined by Chief Justice Roberts and Justice Scalia, Thomas, and Alito. Justice Kagan wrote the dissent, joined by Justice Ginsburg, Breyer, and Sotomayor. In fact, Justice Thomas wrote a separate opinion in which he said he doesn't believe the Establishment Clause even limits what state and local governments do. From his perspective, if a state wants to create an official church, if a state wants to acquire religious participation, there's no problem. And then in a part of the opinion joined by Justice Scalia, Justice Thomas said, at most the Establishment Clause limits the government from creating a church or legally coercing religious participation. Nothing else violates the Establishment Clause. So for conservative justices, prayer in public schools or other government events are constitutional. Religious symbols of all sorts, nativity scenes, Ten Commandment monuments are okay. The government can give unlimited aid to religious schools. For the liberal justices, they still believe that the Establishment Clause is but a wall that separates church and state. They believe that as much as possible, our government should be secular. The current court, without Justice Scalia, is split 4-4 between these two positions. If Merrick Garland or a Clinton nominee replaces Justice Scalia, I think there will then be a majority to limit the ability of government to aid religion or religion to be a part of government. But if Donald Trump wins, I think there's no doubt that the justices he would pick to replace Justice Scalia and others would say nothing ever violates the Establishment Clause except the government creating a church or coercing religious participation. No prayer in schools would be unconstitutional. No religious symbols on government property would be unconstitutional. No aid to parochial schools would be unconstitutional. I picked 6 examples: abortion, affirmative action, campaign finance, death penalty, guns, separation of church and state. I could pick a couple of dozen other examples. The outcome of this election will affect all of us. It will affect all of us often in the most important and intimate aspects of our lives. That's why I believe there is no issue more important for the November presidential election than who's likely to pick 3 or 4 justices for the United States Supreme Court. Thank you.
Thank you, Professor Chemerinsky. And now we're going to have our Q&A, questions and brief comments so everybody gets a chance. There are 2 mics. Please line up at this side or the other side, and we will take your questions in order. Thank you. Thank you
Please,
so much.
Line up, come down this side here. Harry, over here, please. Line up, come down this side and down that side. We'll alternate one mic and then the other. Get in line. Harry, it's yours. Come on. Come on.
Okay. I would like to know, with reference to the appointment of Garland, why can't somebody sue McConnell for deprivation of constitutional right to have Garland at least considered?
The simple answer is that each House of Congress makes its own rules for its proceedings. And so if the Senate wants to say, our rules are we're not going to consider a nominee in the context of an election year, that's their prerogative under the Constitution. I mean, what frightens me is, imagine Hillary Clinton is elected president, but Republicans keep the Senate. Could they then say, we think the court's just fine with 8 justices, we're not going to process anyone for 2 more years? Yeah, I think they could. I don't think anybody could sue. And of course, even if you could force them to hold hearings, even if you could force them to take a vote, they could have a no vote. You can't force them to confirm somebody. That's the prerogative of the Senate. What I say to my students here, this is one of so many areas where the Constitution assumes the good faith of those who govern us. And if a body of Congress doesn't act in good faith, there's really nobody to sue. There's no cause of action here. A more technical legal answer is that there's no doubt that the lower courts would say this is a, quote, political question left for Congress and the president to work out. I wish there were another answer. I don't think there is. And been part of lots of conversations with terrific lawyers. Everyone's searching for a way, but everyone's conclusion is there really isn't.
In light of the fact that our currency has "In God We Trust" on the bills, how does the Supreme Court justify that in terms of the Establishment Clause?
I always tell my students if that bothers them, I'm glad to take the problem off their hands. Justice O'Connor, when she was on the court, said there's a thing called ceremonial deism. That's her phrase. Where she said, we invoke God for ceremonial purposes. In God we trust is on money. If you argue in the Supreme Court, go to the Supreme Court, before each session they say, God save this honorable court. And she says, we've accepted those by virtue of tradition. If we really wanted to be strict about it, we would exclude those. But Justice O'Connor would say, those forms of ceremonial deism don't justify things like putting prayer in schools, putting religious symbols on government property, having the government give aid to parochial schools that's used for religious indoctrination. In fact, not long before she left the court in June 2005, she said very eloquently, why would we want to trade our system with regard to separation of church and state for another that's worked so poorly in other countries? And so I think the answer to the question is we've just come to accept certain ceremonial things like in God we trust, but it doesn't tell us anything. And if one wanted to be really strict, one could say, no, that's unconstitutional too. I don't think the court's willing to go there.
Hi, first of all, I have to thank you for your inspiring talk.
Oh, thank you.
And I also have to ask you a question based on this. All right? When I was 26 years old, I was a Peace Corps volunteer in Ethiopia, and I'm sure you're aware that justices of the Supreme Court would go visiting in different countries. I happened to be at the American Embassy in Addis Ababa, and there was Justice Potter Stewart, you see how old I am, and Justice Thurgood Marshall. And a very naive 26-year-old said to him, Justice Potter, how do you keep your own views on things out of your decisions? And very graciously, he said to me, and I'll never forget this, when I put on my robe, then my view does not count. So my question before you start is, I know the Constitution. It has lots of spaces. But how do two people, let's say Ginsburg and Scalia, look at the same words and come up with such different views?
What Potter Stewart said to you is a myth. It's nonsense. If it were more polite, I'd use an expression that begins with bull. And let me try and explain why. And justices seem to propagate this myth, but it isn't true. Some of it is, as you say, the Constitution is written in very open-ended language. What's cruel and unusual punishment? What's due process of law? What's equal protection? Inevitably, that's going to depend on justice views. But there's another reason why justices can't keep their views out that's much more important and often overlooked. No right in the Constitution is absolute. Not even freedom of speech is absolute. Not even the prohibition of race discrimination is absolute. The government can abridge free speech if it has a compelling interest. The government can discriminate based on race if it has a compelling interest. But what's a compelling interest? There's no litmus test for that. In the affirmative action area, the question is diversity in the classroom a compelling interest? Ruth Bader Ginsburg would say yes. Sonia Sotomayor would say yes. Antonin Scalia and John Roberts would say no. But you can't answer the question of what's a compelling interest apart from the values of the person. So often, constitutional law involves balancing competing interests. Balancing is inherently subjective. In fact, take an example. The Fourth Amendment says no unreasonable searches and arrests. What's unreasonable? You can't answer that apart from one's own values. That's why Justices Scalia and Ginsburg, albeit close friends, so often disagreed. So I think to say justices put on the robes and their values don't matter is just silly. Of course their values matter. That doesn't mean that every case depends on their values. There's instances where the law is clear. But often in the hard cases, their values matter. That's why the life experiences of the justices, the views of the justices really affect the outcome of a decision. It's why the presidential election matters so much. Who Donald Trump will put on the court will be very different than who Hillary Clinton will put on the court, and that's what will affect all of us. So that's my answer to the question.
So I just want to add one thing, and that is your talk needs to resonate in every head in this place and for them to pass it on, because these justices will be picked, as you said, to reinforce the political views of the candidate.
And I tried very hard in presenting to do so in a way that if you believe there should be no abortion rights, no affirmative action, no Citizens United was right, gun control is wrong, and so on, you could say, yes, we should elect Donald Trump to do those things. And of course, if you believe there should be abortion rights and affirmative action and campaign finance regulation and gun control, then you'd say we really need to elect Hillary Clinton. But that's what's at stake. And it's also important in that regard to keep in mind the most long-term legacy of any president is who that person puts on the Supreme Court and the lower federal courts. William Rehnquist was put on the Supreme Court in 1971 by Richard Nixon, and he remained on the court until 2005 when he passed away. John Paul Stevens was put on the Supreme Court in 1975 by President Gerald Ford, and he remained on the court until he was 90 years old when he stepped down in 2010. Clarence Thomas was 43 when he was confirmed in 1991. If he stays till he's 90, he'll be there 47 years. That's what's at stake with the presidential election.
Two related questions.
Let's do them one at a time.
First question has to do with the nature of the Supreme Court justices, all of whom seem to be coming from an academic East Coast kind of background, Ivy League type of background. Do you feel that's good or bad for the way the court works?
Of the current 8 justices, and I'll include Justice Scalia, the most recent to leave the bench, all 9 of them went to Harvard or Yale Law School. Justice Ginsburg began at Harvard Law School and then transferred to Columbia for her last 2 years when her husband took a job at a New York law firm. I think there should be justices from the University of California Irvine School of Law.
Any others?
And should President Clinton call me, which she's not going to, I'd accept another who went to Harvard Law School on the court. I think there should be more diversity in terms of that. But it goes beyond that. When Justice Scalia was on the bench, Every borough in New York but Staten Island had a justice grow up there, but only 2 of the justices grew up west of the Mississippi, Justice Breyer and Kennedy, and only 1 Justice Kennedy was appointed from west of the Mississippi. Except for Justice Kagan, all had been Federal Court of Appeals judges. When Brown versus Board of Education was decided in 1954, none of the justices had been Federal Court of Appeals justices. In 1954, when Brown was decided, you had Earl Warren, who had been the governor of California, Hugo Black, who had been a senator from Alabama, William Douglas, who had been the head of the Securities and Exchange Commission, Felix Frankfurt, a law professor. On the current court, only 1 of the justices was ever a trial court judge. And I think the court suffers from that lack of experience. So I'd like to see far more diversity, not just in terms of where they went to law school, but where they grew up, what they did before going on the bench, what their experience was as lawyers. You had a second question.
Do you believe there should be a tenure or a time limit or an age limit on how long the justices serve?
Yes, as I said to this audience before, I favor 18-year non-renewable terms for Supreme Court justices. Some of that is, thankfully, life expectancy is a lot longer now than it was in 1787 when the Constitution was written. As I mentioned, Clarence Thomas was 43 when he was confirmed in 1991. So this doesn't sound ideological. John Roberts and Elena Kagan were each 50 when they were confirmed for the court. If they serve till they're 90, they'll each be on the court for 40 years. That's too much power held by a single person for too long a period of time. Also, too much depends on the accident of history as to when vacancies occur. Richard Nixon got to fill 4 vacancies in his first 2 years as president. Jimmy Carter got to fill no vacancies in his 4 years as president. 18-year non-renewable terms will mean a vacancy every 2 years. Every president would get to pick 2 people per term to the Supreme Court. But I think that would take a constitutional amendment, and that's enormously difficult to do.
Just today, I heard on the news a bill had been introduced in Congress to remove the president's authority to determine the fate and disposition of the prisoners remaining at Guantanamo. And it just seemed to me that since they're considered enemy combatants, that's infringing on his rights as commander-in-chief. So I guess my hypothetical questions to you is, do you agree with that analysis? And if this was a law and was brought before this Supreme Court today, how do you think they would rule on it?
The first Guantanamo detainees were brought there over Martin Luther King Day weekend in January of 2002. We're now September 14th, 2016, and there are individuals who've been incarcerated for over 14 years who have never had a trial or meaningful due process. President Obama, in taking office in January of 2009, said he wanted to close Guantanamo within a year. Guantanamo is still there. Congress passed a law that prohibited the transfer of Guantanamo detainees to prisons in the United States and have them tried in federal courts in the United States. So I think that's some of the explanation. I think progressives deserve some of the blame here. When George Bush was president, Guantanamo was something that was a symbol and was strongly argued against the indefinite imprisonment of individuals without trial. With Obama as president, the progressives seem to have lost interest in Guantanamo. There are, as we speak today, 61 prisoners still left in Guantanamo. That's from the maximum of 790 who were there. President Obama has slowly either cleared individuals released because they're not dangerous, or found countries, Palau, others to take the detainees. Congress, if it passes this bill, will surely have it vetoed by President Obama. I don't think there's any way there would be the way to override the veto. You ask, if it gets to the Supreme Court, what would the Supreme Court do? I think the Supreme Court would declare that unconstitutional as a violation of separation of powers. And I can give you a recent Supreme Court case about separation of powers to back that conclusion.
Has the Supreme Court ever weighed in on gerrymandering, and do you think it should?
Yes. Yes and yes, in that order. In 1986, in a case called Davis versus Bandemere, the Supreme Court said that gerrymandering denies equal protection. Gerrymandering is nothing new. The phrase gerry comes from a congressman in New York at the time the Constitution was written. Gerrymandering, as everyone knows, is where the political party that controls the legislature draws election districts to maximize seats for that party. What's changed now is computer programs have made it much more possible to engage in effective gerrymandering. It used to be that we're all taught people elect their representatives. Now it's representatives who choose their constituents. And so you can have a situation like in North Carolina where Republicans get 52% of the vote, but they can gerrymander so they have 75% of the seats in the legislature. But in 2004, in a case called Veith versus Jubileer, the Supreme Court ruled that challenges to gerrymandering are political questions that shouldn't be adjudicated by the court. It was 5-4, Justice Scalia writing, joined by Chief Justice Rehnquist, and Justice O'Connor, Thomas, and Kennedy joined. And the court said, we don't want the judiciary to be involved in this. 2 years later, in a case called Lulek versus Perry coming out of Texas, the Supreme Court again ruled 5-4 that the federal judiciary shouldn't be involved in gerrymandering. Here, it's Justice Scalia, joined by Roberts, Kennedy, Thomas, and Alito. The reason I mention that is that those two cases that said there can't be challenged to gerrymandering were both 5-4 with Antonin Scalia in the majority. I think depending on who replaces Justice Scalia, you could have a majority of the court that's willing to say that gerrymandering, at least past a certain point, violates the Constitution. It really is tremendous vote dilution. Depends on who replaces Justice Scalia.
Thank you for being here. I have a question in regards to the Second Amendment. Do we still have a well-regulated militia? Because if you don't, wouldn't the Second Amendment be useless?
Well, you're right. The Second Amendment says a well-regulated militia, being necessary to security for free state, the right of people to keep and bear arms shall not be infringed. And what gun control advocates say is you have to understand that the Second Amendment was about a right to have guns for the purpose of militia service. That's all that it was about. However, Justice Scalia, in the case I mentioned, District of Columbia versus Heller, said that the Second Amendment has what he called, and I'm quoting, a prefatory clause and an operative clause. He says the operative clause of the Second Amendment is the right to people to keep and bear arms shall not be infringed. And he says a prefatory clause can't negate the meaning of an operative clause. Justice Stevens, in his dissent, said all of it's operative language. All of it has to be given meaning, and that Justice Scalia's interpretation would have the Second Amendment mean the same thing as if it just said the right to people to keep and bear arms shall not be infringed. Gun control advocates believe the Second Amendment is about a right to have guns for militia service. Gun rights advocates have to believe that the Second Amendment is the right of people to have guns, at least in their homes, for the sake of security. The current court without Justice Scalia is split 4-4 between those two views.
Hi, I want to thank you for coming today.
Thank you for coming. Thank you for having me.
The question I have is regarding the recent news things that I've heard about Snowden and the potential to ask President Obama for a pardon. I was wondering if you could explain briefly, how does the treason laws and that all work in the, I guess it can't go to court, and so the Supreme Court can't say anything. Is that determined by legislature, or is it part of the Constitution, or a combination?
Sure. Let me break that down into a few parts. First, the president can pardon anyone accused or convicted of a crime. Remember, Gerald Ford pardoned Richard Nixon, even though Richard Nixon had never been convicted of anything. Anyone accused or convicted can be given a pardon. So, President Obama could give a pardon to Edward Snowden. I would be shocked beyond belief if he did that, But he could do that. Second, it's unlikely that Snowden, if he ever came back, would be charged with treason. Actually, treason and the procedures for finding it are defined in Article 3, Section 3 of the Constitution. And treason is limited to levying war against the United States. I mean, assisting the enemies of the United States in levying war. I don't think he'd be tried with treason. He would be tried instead, this is my third point, for violating a couple of statutes that were adopted early in the 20th century that have then been amended that make it a crime to disclose confidential information. That's what his crime would be. Now, there's a very significant penalty that could be attached, but I don't think anyone would think of charging him with treason, though some believe what he did makes him a traitor. His crime would be disclosing confidential information in a way that violates federal law. Thank you.
Thank you, Dean, for coming
you.
and
Always my pleasure.
educating us every
Always
year.
my pleasure.
Thank you. And if President Hillary Clinton does select you, we'll all write letters for you.
Thank you. I'm not going to give up my day job, which I love. So it's.
Right.
But thank you. Thank you.
You're welcome. My question might not be Supreme Court, although eventually it could come there. It's a constitutional question. Perhaps I'm stuck in my civics class from decades ago. But the First Amendment, freedom of speech, I feel that it's really gone, it's on steroids. What happened to libel? What happened to slander? And as we evidence from Donald Trump rallies, anything is acceptable. And there seems to be no recourse. So how far can we take freedom of speech? And are there any limits?
Sure, there are limits. It's a great question that I don't have a very good answer to. Of course there's limits on free speech. There's no right to shout fire falsely in a crowded theater. Somebody who did that could certainly be punished. In terms of your example of libel and slander, defamation suits, people bring and win those suits all the time. Now I'll talk about the limits that exist with regard to it. False advertising isn't speech protected by the First Amendment. The Federal Trade Commission brings actions against those who engage in false advertising all the time. I do think that over time our society has become much more protective of speech. Now to get to your specific example, what about what Donald Trump says or somebody says about Hillary Clinton? The Supreme Court has made it very difficult for those who hold public office or run for public office to win a defamation suit. This isn't new, though. In 1964, in a case called New York Times versus Sullivan, the Supreme Court said that somebody who holds public office or runs for public office should find it very difficult to win for defamation. They have to prove, with clear and convincing evidence, that what's said about them is false, and that the person who said it knew it was false or acted with reckless disregard of the truth. The Supreme Court said it's essential that we have breathing space for freedom of speech, that even false speech needs to be protected. So somebody who holds or runs for public office, like Hillary Clinton or Donald Trump, is going to have it very hard to win in a defamation suit. But there's still the possibility, especially for others who don't hold public office, to win. And there's other ways. I'll give you an example that probably all heard of. Hulk Hogan successfully sued Gawker for invasion of privacy and intentional infliction of emotional distress. Gawker's free speech defense wasn't accepted.
Right. Thank you. But, all right, a follow-up question.
Sure.
I'm quite prolific on Facebook. Now, that's written.
And I've never
it's
seen
expressive.
Facebook. I may be one of the only people in this room. I've literally never seen Facebook.
Well,
I've never seen Twitter.
You can friend me.
But I'm not
And
on
then you'll
Facebook,
see.
so I can't. And the reason for that is I get more email a day than I can possibly keep up with. And I'm struggling constantly to make sure I answer everybody's email that day. I don't want another source of email.
Right. So my question is, perhaps some of the things not perhaps, but the posts that I share with my written message is my opinion. Sometimes it might not be 100% accurate, but it's my opinion. So where would I stand if a case were brought against me?
Opinion is protected under the First Amendment. Defamation exists for the publication of false statements about a person that are injurious to reputation. If you want to say about me that you think that I'm a sleazy person, you can put that on your Facebook page. If you want to say, though, that I sexually harassed a student, which I've never been accused of, that's false. I'll sue you for defamation. I probably won't sue you. I like you. But I could sue you for defamation. That's the line. What's defamatory is a publication, and putting on Facebook I think would be counting as publication, of a false statement of fact that's injurious to the reputation of another person. That's the definition of defamation.
But what's it about a politician?
Pardon? Politicians, in order to win for that, have to prove with clear and convincing evidence that what was said was false and that the person who said it knew it to be false or acted with reckless disregard of the truth. That's New York Times versus Sullivan, 1964.
I, too, want to thank you for your generosity in coming down here and talking to us.
Thank you.
As
Truly
you do
my
each year.
pleasure. Thank all of you for having me and for coming.
Jonathan,
You don't know
Do you
it, but
have-
this audience is very well schooled on Shelby County versus Holder. Before you came in, we talked about our legislative action for the day, which is to put preclearance back into the Voting Rights Act by passing the Voting Rights Advancement Act. When you said you're going to do 6 areas, I jotted down guesses. One of them was voting rights. Is Shelby County versus Holder history if Hillary gets her appointment? And what about LGBT rights and search and seizure? Is Strieff v. Utah the law if Hillary appoints?
Okay.
You can unpack that.
I'll do all 3 of those questions. Shelby County versus Holder, 5-4, came down on June 25th, 2013, strikes down key provisions that you refer to preclearance of the Voting Rights Act. It's Roberts writing, joined by Scalia, Kennedy, Thomas, and Alito, Ginsburg, Breyer, Sotomayor, and Kagan dissent. It's 4-4 now. I think that if Merrick Garland or a Democratic appointee replaces Justice Scalia, there'd be a majority to reverse Shelby County. Second, LGBT rights. I actually believe this is an area where even if Donald Trump wins, and even if there's Republicans appointed, I don't think the Supreme Court's going to reconsider the marriage equality decisions. I just think our country has come so quickly to accept marriage equality for gays and lesbians. I don't think that there's going to be a receptive court to turn back the clock there. Final example you gave was Utah versus Strieff. This was a Supreme Court decision from this year. Simple facts. Police in Salt Lake City got an anonymous tip that there was drug dealing going on in a house. A police officer, Douglas Frackle, was watching the house. He saw a man go in and quickly come out. He stopped the man. He asked the man his name. The man answered honestly and said his name was Edward Strieff. Frackle did a check to see if there were any outstanding warrants on Strieff. There was an old arrest warrant for a traffic violation. Strieff gets arrested based on that warrant. The officer does a search, instant of the arrest, and finds drugs. The issue is, do the drugs have to be excluded? The police stop of Strieff violated the Fourth Amendment. Utah conceded that the stop violated the Fourth Amendment. There was no reasonable suspicion. The Utah Supreme Court said the evidence has to be excluded. This is the fruit of the poisonous tree. It's a result of a Fourth Amendment violation. But the Supreme Court, 5-3, reversed and said the evidence could come in. Justice Thomas writes, joined by Chief Justice Roberts, Justice Kennedy, Justice Breyer, and Justice Alito. Justice Thomas said once the police found that there was an outstanding warrant, that then meant the police could do the search. The fact that it was an illegal stop doesn't matter. Justice Sotomayor writes a passionate dissent, joined in large part by Justice Ginsburg, in which she talks about how degrading it is to be stopped by the police. She talks about the large number of outstanding arrest warrants that exist. She talks especially about what this means in minority communities. She discusses how parents of color need to talk with their children about what to do when they're stopped by the police. And she says this is really going to encourage the police to illegally stop people knowing if they find an outstanding arrest warrant, they can then do a search and any evidence gained will be admissible. So I think those were your three examples.
I have a short question, I think. The Supreme Court and justices have talked about the right of privacy. How does this pertain in a world where we have hacking of internet communications and publishing them on all the media? Where does...
Privacy is an umbrella term that refers to many things. One thing is what I'd call freedom from intrusion. Think of the Fourth Amendment that I was just saying in response to the question. The police can't come into your house unless they've got a warrant or there's an emergency. That's privacy. The police can't listen to your phone conversations through wiretapping unless they get a warrant. That's privacy. A second thing that privacy means is our ability to control information. When we think about databases, that's what we're worried about, is the ability to gather and collate information about all of us. And a third thing that privacy means is autonomy. The Supreme Court has said, for example, under privacy, there's the right to purchase and use contraceptives. There's the right to abortion. There's the right to engage in private, consensual, same-sex sexual activity. All of that is part of privacy. There's no doubt that technology creates more threats to privacy now than ever before. And it's another topic that I'd be glad to come discuss with you. But the law has not kept up with the threats to privacy that exist. I mean, take drones as an example. Drones really give the ability of the police to gather information, and there's no legal regulation of it in order to protect privacy. So, but again, that's a long topic, and be glad to come talk about it in length. Thank you. So thank you.
Thank you. Are there any more questions or comments? In which case, we want to thank Professor Chemerinsky with all our heart. Wonderful.
Thank you.
And thank you all for coming.